unfair dismissal, disciplinary procedure, financial settlement, job description, trade union, minimum wage, employment tribunal, work permit. I didn't think I was being paid the minimum wage, and firstly I asked my line manager to help me. When I got no response, I contacted my trade union. The next day I was called into the office and given a week notice. I'm 65 next week and still very fit. I enjoy my job. When the managers asked to see me, I thought they wanted to give me a birthday card. They gave me my dismissal cards instead. It's a disgrace. They are always complaining of being short-staffed, but they still kick you out when you reach a certain age. I had only been here a week when I got pregnant. They told me I couldn't work here anymore because I couldn't be able to stand behind the counters all day. I regret that this financial quarter has been unprofitable and we have to drastically cut off costs. Usually I do what I can to keep all staff, but in the current situation I'm afraid we will have to let some people go. It was only a bit of fun. The customers didn't see what we were doing. They say we should enjoy our work, but they never let us. Up to a point, I understand why the management took disciplinary action, because what we did was a bit stupid. But we certainly didn't deserve the sack. At the moment, our staff turnover is rather high. But the important thing is whether we can reduce sick leave and absenteeism over the coming year. Employment law is important for the management companies. For example, contracts of employment and job descriptions are formal documents which companies must produce when there is a dispute. Your employer must have a good reason for dismissing you. You normally cannot claim unfair dismissal unless you have had 1 year's continuous service. Regardless of the reason for the dismissal, the employer must act fairly and follow the correct procedure. The potentially fair ways of dismissing an employee are for conduct at work, culpability, redundancy, retirement, statutory restriction, or another substantial reason. A substantial reason could be something such as an unresolvable personality clash with a college. Even if you do not have 1 year's service, your dismissal may be automatically unfair if, for example, you are struck because you take statutory paternity leave. Summary: there are two types of dismissal which can lead to claim for redress by the employee. The first is unfair dismissal, which is a statutory concept. Employees must have 1 year's continuous service to claim for unfair dismissal. Employers must show they had a good reason for the dismissal and that they acted fairly in the procedure. Wrongful, statute, reserve, conduct, provision, tribunal, dismissal, damages. Employment law, common law, breach of contract, retirement age. Actually, generally, usually, demonstrably, crucially. Okay, this one is the transcript 2.6. Extract 1. Finally, there is what the EIA terms another substantial reason. In other words, there is an overwhelming reason to dismiss an employee. For example, if an employee is sent to prison, or less drastically, where an employee just cannot work with a college because of personality clash. Benny, Zagent, and Jefferson point out in Employment Law and the Blackstone's Law Question and Answer series, one of your cortex. This edition was published in 2007 and this particular clause is open to wide interpretation. Extract 2. By the way, I see that some of you are using the Cornell note-taking system. That's very good. Do you all know about this? No? Right. Well, if you want to know more about it, I suggest you look at How to Study in College by Walter Polk, the 9 editions, published in 2007, and it's very good. And it should be in the university library. Extract 3. So to get back to the main topic, I said we could look in more detail at two of the heads. There are on the slide, the third and the fourth, redundancy and retirement. Redundancy first. This is the complex areas in employment law. One definition of redundancy is given by the Free Dictionary.com on the verb is the state or fact of being unemployed because work is no longer offered or considered necessary. Typically, this means that someone's job disappears, and this can happen a number of reasons, not just advances in technology which make some type of job obsolete. Extract 4. Okay, so now on what grounds an employer can dismiss an employee fairly, and under these heads, what rights an employee might have to claim unfair dismissal. To quote Bennis, Jen, and Jefferson, the basic of unfair dismissal is statutory, therefore it is governed by statute. In a case where the dismissal is not automatically unfair, the employee must prove that he or she is qualified and has been dismissed. The burden of proof then switches to the employers to show that they had one of the five possible potentially fair reasons: capability, conduct, redundancy, statutory illegality, and some other substantial reason. Appeal, redress, genuine, justify, statutory, summarize, procedure, retirement, substantial, dishonesty, legitimate, redundancy. Okay, so this one is a long reading. Claiming unfair dismissal is the unusual way a SAC employee will seek redress against an employer. The rules for the claiming unfair dismissal are relatively straightforward as they lay down in various statutory provisions. However, there are numbers of disadvantages. Firstly, you have to have at least 1 year's continuous service with the same companies in order to be able to claim unfair dismissal. It seems that sometimes employers take advantage of this and sack employees after they have worked for 11 months. Secondly, there is a cap on the amount of compensation you can claim in an employment tribunal. Thirdly, if you don't belong to a union, you may need to employ an expensive barrister to present your case. Extract C. So we skip extract 2, extract 3. Sometimes it is a good idea in cases of unfair or wrongful dismissal to employ a barrister. Usually, there is very expensive, but it is necessary because a barrister will present your case in the best possible way. Also, a good barrister is important because under English law, you have to make sure that the rights of both the employers and employees are fully protected. Extract 4. Under Section 98 of the Employment Rights Act 1996, there are 6 reasons under which an employee can be fairly dismissed. First of all, there is a conduct or the way the employee behaves at work. Secondly, capability, which means the skill and qualifications the employee needs to carry out the job to the required standard. Thirdly, redundancy, where a company or organization closes down, for example, or where there is no longer any work for the employee to do. Retirement is the next reason, where the employee reaches the normal retirement age. Then we have statutory restrictions, where an employee will be breaking the law by continuing to perform the job. The final category is called under the substantial reason. This has been defined as an overwhelming reason to dismiss an employee. An example might be where the employee has been given a prison sentence. Abolition, removal of a practice, a law or punishment. The abolition of slavery, death penalty. Homicide, an act which causes the death of another person, involuntary, unintentional, or not deliberate. It's justifiable, allowed by law because there is good reason for it. Malice, the wish to harm other people. Manslaughter, killing someone without intention or with mitigating circumstances. Murder, killing someone with the intention of doing it. Perpetrator, the person who commits a crime. Provocation, an action or statement that is intended to make someone angry, recklessly, without thinking about danger. Murder. In English law, murder is considered the most serious form of homicide. For the crime of murder to be proved, the perpetrator must have intended to kill or intended to cause serious injury, where that is virtually certain to result. Following the abolition of the death penalties in 1965, the mandatory sentence for murder is life imprisonment. There are a number of defenses to a charge of murder which can be termed mitigating circumstances. These include self-defense and provocation. There is also the defense of diminished responsibility, which refers to the mental state of the accused at the time of killing. A successful defense could lead to conviction on the lesser charge of manslaughter. So we have the word serious injury when someone is hurt very badly, death penalty, mandatory sentence, life imprisonment, mitigating circumstances, self-defense, diminished responsibility, and mental state. Okay, we have other words as well here. Their vocabulary categorize, in form of neutral and mark. Hit, batter, thump, and whack. Sad, heartbreaking, tragic, violent, brutal, ferocious, savage, vicious. Ugly, grotesque, gruesome, and monstrous. Fall, plummet, and plunge. Okay. From the evidence in the case, it clears that the victim was hit a number of times in a violent attack. The lady managed to escape from the attacker but subsequently tripped over and fell down the stairwell to her untimely death. It generally accepted that if the attacker intends to cause harm, the person can be found guilty of at least manslaughter. In this said case, we undoubtedly have such a situation. It's fair to say that the facts here fall into the category of the so-called escape cases. So we could relate them to the factors laid down by Lord Katz in DPP's and Delhi's and Maggie's 1980 in the Court of Appeal. It's unlikely that a defense claim of a break in the causation between the original attacks and the deaths of the victim would result in an acquittal. But there may be a question about whether the attacker would be convicted of murder or manslaughter. Okay, now let's go to the next one called Spineless Covert. The devastating widow of the train guards branded the two youths found guilty of causing her husband's tragic death spineless covers as they were bundled into a prison van to start their sentences for manslaughter. Philomena Scott added that the 2 years jail term they were each given was ludicrous and pathetic. She accused the defense of fluffing up the evidence in order to obtain a shorter sentence. The two youths claimed they were merely taking part in a prank, which got out of hand. They hurled massive slabs of concrete onto a railway line from a bridge when a train was passing underneath. One of the concrete slabs smacked into John Scott's head when he was working in a guard's van. He was killed instantaneously. The judge accepted that the boys did not intend to cause Mr. Scott death, but their actions were unlawful and reckless. They had, however, shown considerable remorse about what they had done, and Mrs. Scott described the judge as a complete imbecile and vowed that she would campaign as long as it took to get justice for her husband. Manslaughter. A group of people went to visit the pub during the evening. There was disagreement between members of the group, and there was some fighting and scuffling. The victims, a doorman at the pub, intervened to try to stop the fight. The pub manager asked the group to leave. They went down to their 4x4 vehicles in the car park. The accused got into the driving seats and 3 other people from the group got into the passenger seats, and the victim stood in front of the cars, and the accused edged the car up to him and then stopped. The victim then started arguing with one of the passengers, but this had he put his head through the car's window to grab him. The car was driven off with the victims halfway through the car window. As the car sped up the road, the victim's feet got caught in the front wheels and he fell off the road. He was run over and suffered severe chest injury, and he was pronounced dead 2 hours later. It is clear that in this case, the accused could face a murder charge if the intention to kill could be proved. Alternatively, a charge of voluntary manslaughter could be brought if there was intent but mitigating circumstances. Finally, the prosecution could seek involuntary manslaughter by reason of unlawful and dangerous act, or dangerous act, gross negligence, or recklessness. It is equally clear that there are possible defenses against each. Firstly, it is difficult in this case to prove intention to kill. Secondly, the act of driving away cannot be held to be unlawful in itself, but clearly it could be seen as dangerous, grossly intelligent, or neckless under the circumstances. However, even if the driver was negligent or reckless, there may be well evidence to support defenses of self-defense, duress, or necessity. The charge given by Lord Morris, both by a guest in R. and Palmer, 1971, AC 814 HL, is quoted both in Agbold, 1999, para 1941, and in Smith and Hogan, 2002, page 263. If there has been an attack so that defense is reasonably necessary, it will be recognized that the person defending himself cannot weigh to a nicety the exact measure of defensive action. Oh, thank you very much. This is the end of the reading review. Good luck for the exam.